Hello and welcome, everyone. Today we are going to take a look at a so-called advisory opinion of the District Court of Munich that was delivered last year in July in a dispute between ZTE and Samsung. An advisory opinion is not a final decision, so it is more or less something that can happen in German proceedings, civil proceedings, not just patent infringement proceedings, where the court indicates towards the parties its views, especially on legal issues, to give them basically an opportunity to maybe adapt their case or offer additional input, etc. The specific opinion here of the Munich District Court is very important or very interesting because the court gave very specific guidance on several elements which are very relevant for front litigation, and also, in a sense, intended to have this guidance more, let's say, more public, to give an impression of how the court sees specific issues, which, as I said already, are very important for front-related proceedings. Three aspects particularly relevant here for us that we're going to focus today. The first one is the obligations of the parties under the Huawei versus ZTE framework, obligations that refer to the parties' conduct in licensing negotiations. This is one major part of the decision. The other one is valuation and determination of front terms and conditions. Here the court provided some input of how it sees specific things, for example, royalty calculation methods, what is the best way to talk about valuation in the proceedings, which are the best means to use in order to reach a front result, and this type of issues, which until now had not been very prominent maybe in German proceedings. And the last one, but not least, definitely the relation between parallel proceedings pending in different jurisdictions. Here the court provided input on how it sees the role of German courts in cases where, as we had here, there are proceedings pending in different parts of the world. And it also provided some input on the recent case law that has been developed in the UK on interim licenses and how the court thinks that this type of remedies should be dealt with from a German perspective. Now, before we start, maybe very brief also the background of this decision. I think it's important for us to keep in mind what has happened so far. So what the court is based here, what the opinion of, on which framework the opinion of the court is based. We have, of course, primarily the Huawei versus ZTE ruling of the Court of Justice of the EU, which in the last 10 years has been the primary source when it comes to front-related litigation in the EU. So the court, of course, referred to that. There had been in 2020 two decisions of the Federal Court of Justice, which is the highest court in Germany, also giving specific guidance regarding the duties of the parties in negotiations, but generally how to treat SCP-related cases. And what we also had more recently was a decision of the Higher District Court of Munich in a dispute between HMD and VoiceAge, where the court again gave some insights, or let's say set up a new way to a certain extent to view front cases, focusing particularly on security payments and the issue of willingness on the side of the implementer. As we're going to see, the District Court of Munich here had some concerns about the later decision. So the decision of the Higher District Court of Munich, it positioned itself to that as well and disagreed in a couple of instances. So it's going to be very interesting also to see how this evolves, because these proceedings have been now placed before the Federal Court of Justice, and we're expecting a new decision relatively soon. So this is maybe a little bit the background in which this decision is moving, and what can maybe be expected in the future, especially when it comes to the situation in Germany. Now here, very quickly, some of the relevant facts of the case before we go into the legal reasoning. We're going to cover only the things here that are relevant for understanding the opinion of the court. The litigation between ZTE and Samsung is a global one. It has proceedings, as I mentioned already, in the UK, pending between the parties, but we have also other jurisdictions involved. We have proceedings pending in China, proceedings that were pending in Brazil. What is interesting here is that there was a license already between the parties that expired in the end of 2023. And then the parties had almost a year time to negotiate a license, a new license, which they didn't manage to conclude. So at the end of 2024, it was Samsung that launched proceedings in the UK before the High Court, asking, among other things, for a global rate determination. ZTE's reaction was to file an action in China before the Chongqing Court and ask for a global rate determination there as well. And shortly after that, in January 2025, ZTE filed infringement actions against Samsung in Europe before the UPC and also the Munich District Court. A month later, and then also in March 2025, Samsung filed itself infringement actions against ZTE in Munich. So here, important to keep in mind, when the court provided this advisory opinion, there had been cases pending from both parties. So there were proceedings ZTE had launched against Samsung, but there were also proceedings which the same court had to deal with, which Samsung had initiated against ZTE. Apart from the infringement trials, in March 2025, Samsung also filed in the UK proceeding this application for an interim license declaration. In very short terms, what this is about is basically a request of the implementer here in the present scenario to the court to declare that a patent owner that would be willing would have granted an interim license, waiting for the court to make a final rate determination. So this is more or less, in very simple terms, the request that Samsung had filed before the UK court. And this request was initially granted with a decision that was delivered in June last year, 2025. The UK High Court granted this interim license declaration. The advisory opinion of the Munich court followed almost a month later. So at the moment that the court issued this opinion here, we're talking about today, there had been already this decision of the court in the UK, which had granted this interim license declaration. Interestingly, this was overturned to a certain extent in appeal in October. And until now, we have not seen also a final decision in this case, neither in the UK nor in Germany. This means that it could be that we will have further progress in these proceedings and that we will eventually also have a final decision of the District Court of Munich in the infringement cases. Whether the court will follow now the legal reasoning or the legal positions that it took here, it remains to be seen. In practical terms, usually the courts follow the opinions they have taken in this type of advisory guidance that they provide. But again, this is something we will need to wait and see when the final decision comes, if any. Now let's take a look at the at the opinion itself, and let's focus on the first part we mentioned before, the Huawei versus ZTE obligations. Here, a very brief introduction. In 2015, the Court of Justice of the EU provided guidance in this Huawei versus ZTE judgment in a sense that it had established mutual conduct obligation for both patent owners and implementers, which could be considered by the court when it had to decide about whether to grant an injunction or other exclusionary measures. So in very simple terms, there were obligations for the patent owner, which if met, there might be an injunction granted if we had a finding of infringement. And on the other hand, of course, there were obligations of the implementer, which if met, the implementer could eventually avoid an injunction despite the finding of infringement in the proceedings. Very shortly, what the CJEU said in the Huawei ZTE judgment was that initially there is an obligation of the patent owner before initiating proceedings to make a notification to inform the implementer about the infringement and they need to take a license. Then the implementer is required to declare its willingness to obtain a license. Patent owner then shall make an offer on front terms. If this offer is not accepted, the implementer shall make a counter offer on front terms. And if this counter offer is not accepted, then you should have a security payment or a security placed by the implementer. So this is in a nutshell the Huawei ZTE framework. And here the court started with the first two, let's call it steps of this framework, looking at the notification of infringement and the declaration of willingness. The court said here that these are steps or elements that are subject to a formal examination, which means that also the lack of these steps can be compensated at the end of the day if the parties actually negotiate. So maybe generally the court did not place a lot of weight in these two first steps if the parties later on have actually engaged in negotiations and tried to work their way to a license. And not only that, the court said in certain scenarios, for example, if you have already an agreement between the parties regarding the same parties, maybe has expired now, or in a case where each party holds the relevant share of the standard and there had been communications about the license before a lawsuit was filed, then a notification of infringement and this declaration of willingness can be obsolete. It would be basically a pure formality to require formal statements in this scenario from the parties. Then when it comes to the SEP owner's offer, the other obligation, the court said when we're talking about the very first offer of the patent owner, then we should apply only minimal requirements. So we should not expect that the very first offer is perfectly frank. Why is that? Because the first offer is a kickoff of the negotiations. So it is a starting point of the negotiations. And usually you cannot expect that at the start of the negotiations you have already the perfect front offer set. Not only that, the court said in principle it's also allowed to offer rates with this very first offer that are above front conditions. Because, of course, during the negotiations, discounts can be offered and the parties can work their way through to a front rate. There is an exception, however, to that. The court said if the patent owner requests totally excessive license fees, seeking to exclude a competitor from using the standard, then this can be problematic. So then this is not really something that can be acceptable. At the same time, the court noted, however, here that this will regularly not be the case because patent owners are basically interested in granting licenses. So a situation where the patent owner has as a goal to exclude a competitor from the market in the SEP context is rather an exception. Having said that, the court made clear that the main focus of the analysis of the court will be on what we call willingness. And what is interesting here is that willingness, so willingness to obtain a license, but also willingness to grant a license here, is something that needs to be examined for both parties. So both the patent owner and the implementer. In more detail, the court said that what usually should be examined is whether the fact that we don't have an agreement yet on a license lies on the sphere of the patent owner or the sphere of the user, which of course really requires an analysis of the behavior of the parties in negotiations, which according to the court here plays a decisive role. So here the court is going to basically examine in simple terms how the parties behaved during the negotiation and try to find who has been dealing in negotiations in a way which basically made an agreement difficult or made it impossible for the parties to agree. A key aspect in this context is also the question of timing. So the court said, what you also should look here is how fast did the parties work towards the signing of a license. Interestingly here, the court said the implementer has in this context an enhanced obligation, which means that you should expect from the implementer to be eventually a little bit faster or a little bit more decisive in his actions. Why? The reason is that he already uses the patent before a license is in place, and in a sense, there is a pressure on the implementer to legitimize the use of the technology. So there is an enhanced obligation to drive negotiations toward the signing of a license. An interesting question, which has been discussed here a lot of times, is the question of how to see negotiations when you have already pending proceedings. So there is a concept that has been discussed a lot that can be derived eventually from the Huawei versus ZTE judgment, and this is the concept of pressure-free negotiations. So, in other words, allowing the parties to negotiate towards a license without the immediate pressure that comes from pending infringement proceedings or eventually an injunction that's coming. Now, the court looked at that here and said this is a concept which can be derived from Huawei ZTE, but in any case, it is a concept of minor importance. Especially for companies with a certain experience in the market, the court said court proceedings are something common and rather influence the negotiations only to a minimal extent. Interestingly, the court thought that Huawei ZTE, the judgment of the Court of Justice of the EU, in this respect seems to be outdated. So having said that, the court turned to the question, what can indicate, particularly from the implementer's perspective, this willingness that we discussed already? And the court mentioned several criteria here, which can be used to assume that the patent implementer has been acting in a willing manner. For example, if the implementer has provided in a speedy way or in a fast way information about the units sold, meaning units using the standard in question, this could be an indication of willingness. Another indication that the court mentioned is if the implementer has a high degree of coverage of licenses. So the court said here there might be a difference if you are talking about an implementer who has taken already licenses for over 50% of the standard compared to an implementer who has taken no or few licenses for the standard. Another indication of willingness is if the implementer is ready or prepared to pay an undisputed amount directly to the patent owner. Keep that one here in mind because this is important for the security payments we're going to talk about in a moment. Other indications could be, for example, offering binding arbitration at an early stage. However, the court said here you need to have negotiated sufficiently first. And of course, an indication of willingness can be the provision of security when the implementer's counteroffer has been rejected. Now, here was one point where the Munich District Court disagreed with the Higher District Court in the HMD voice case I mentioned before, because the Higher District Court thought or expressed the view that placing adequate security is a necessity. So it's something that the implementer is required to do for the court to consider its front defense at all, and for assuming that the user is willing. So if you haven't had security being paid by the implementer, then you wouldn't be able to reach the conclusion that he was willing by judging the rest of its behavior. This is something that the Munich High District Court required that the implementer does. Here, the Munich District Court says this is not necessarily required. So it's one element, of course, that if it's there, it can indicate willingness. But if it's missing or security is not there, this does not mean in any case that the implementer shall be considered to be unwilling. The court gave also an example here. So what the implementer can do to document its willingness if there is no agreement reached or agreement possible with a patent owner. They could, for example, place security and then seriously offer to submit to the arbitral award of the independent institution, which would be requested to determine basically the front amount. Under the condition, however, that this type of activities are undertaken at the right moment, because here the timing is also decisive. If you start doing that or placing security or offering arbitration, etc., binding arbitration even at the moment just before the court would grant an injunction, in the view of the District Court of Munich, this would have a different, potentially less weight than if you have done the same thing at an early stage of the negotiations. So here again, the reiteration by the court that timing is decisive for all of this analysis here. So the court said what is an indication of willingness, and then it also said what is an indication of holdout, of unwillingness. The court tried to define basically what holdout is, and said that holdout exists if obvious next steps towards a license are not taken without a plausible reason. There are, of course, and the court identified that several reasons why you would, from an implementer's perspective, try to engage in delay and to engage in holdout. The court mentioned two here. One is to indicate to the other potential licensors, to the other patent owners, that you're going to fight against taking a license. The court called this the hard cookie argument. Or another reason why you would do that is to reach fast growth through lower prices. If you don't pay, of course, any fees, you can have lower prices than your competitors in the market, and hope then that at the moment you will sign a license, past sales will not be paid at all or would be paid on favorable conditions. So this would be incentives for an implementer to delay, to engage in holdouts. And then the court also indicated some typical circumstances where holdout occurs in practice and can occur in practice. For example, when there is an NDA to be signed to start negotiations, how much time parties take to sign an NDA could be an indication of holdout, of unwillingness, or how much time it's needed for presenting a substantiated offer or counteroffer, or to disclose to the patent owner relevant per unit sales figures, or to respond to specific requests, even in the way that you're being leading the negotiations, you can have indications of holdout, for example, with the individuals involved in the negotiations. The court seems to suggest here that if for a longer time there is no progress in the negotiations, there might be a duty to escalate the case to a higher hierarchy level within the company, basically to move things forward and to get to a solution. So that's on holdout. And then the court went over to the issue I mentioned before, the security payment. Now, this is here interesting because the security payment was not something that was very much dealt with in German litigation in the past. This changed a little bit after the ruling of the Munich Higher District Court, which I mentioned before in the HMD Voice Age case, where the Munich Higher District Court put this requirement into a very central role in the front assessment, saying basically, as I mentioned already, that if you don't have adequate security, then the patent implementer basically cannot refer to a front defense in the proceedings and cannot be seen as willing. So here, the court, the district court, to a certain extent, moved a step further here when it comes to the security payment, and said that placing security can, under circumstances, be insufficient in case that there is already agreement between the parties that one of the parties must pay a license fee, and the only issue which is still in dispute is the amount of the fee. So in this case, if it's certain, if the parties agree, there is no disagreement that one of them needs to pay, and only the final amount is in dispute, the court took the view that there is an obligation not only to provide security, but to pay, actually pay, so the undisputed amount to the patent owner. So it's not an obligation to just place, let's say, an amount in an escrow account, but it's actually an obligation to make a payment, a license payment, as far as and the amount is undisputed. The court said here you could eventually reduce that amount by a safety margin, but basically, in this case, you need to pay for the undisputed amount. What could an undisputed amount be? It could eventually be the amount that has been included in the counteroffer of the implementer, because then you could very well say that at least to that extent, the implementer recognizes that it is under a duty to pay fees and to pay at least this amount of fees. So in this respect, the court said here you can very well assume that there is an obligation for payment, not just for placing security. Why is that? Because the court said where the security payment has a specific function, it's to protect the compensation claim. So in simple terms, you put some money aside for the case that there would be a license agreement or there would be an obligation to pay a license fee, to make sure that there is money there when it's needed. But what the security payment does not do is to make money for new investments available to the patent owner. And this is, in the eyes of the court, unacceptable, at least as far as the undisputed part of the license fee is concerned. Exactly because it is the nature of patent law to have this upfront performance on the side of the patent owners. Because the court said typically you need 7 to 10 years between the R&D investment and the potential license income, so the patent and then the licensing. So if you would not offer or not give at least the undisputed part of the licensing fees to the patent owner directly, then it is difficult to keep up with this upfront investments in innovation and R&D. The court said that this requirement to pay actually the undisputed amount might not be directly mentioned in the Huawei ZTE judgment of the Court of Justice of the EU. However, the court found that it is in line with the negotiation model that this decision describes, and also said that also practically it shouldn't be a problem because the Huawei ZTE decision basically refers to exclusionary measures, so an injunction or the recall and destruction of infringing products from the market, whereas other type of remedies which do not include an exclusion of the implementer from the market are not touched upon, which is the same here with an obligation to pay the undisputed amount, because here you also have no exclusion of the patent implementer from the market. So generally, this is the new element that this advisory opinion here has added, that you have potentially above the obligation to pay a security, to place a security, also an obligation to actually pay an undisputed amount. The court saw here, just to sum this up, this topic up, maybe a need to be a little bit more flexible when we're talking about cross-licensing. The court was here uncertain if you would need to require from both parties to make a security payment for basically examining the front defense and looking at the parties' offers and counter offers. So here the court had some restrictions about that, and in a certain extent also had a different view compared to the Munich High District Court in the HMD Voice case. But this is something which I think is of secondary importance. The main or the most important aspect of this part of this opinion here is that there is this additional obligation of the implementer to pay for the undisputed amount. Now let's see what the court thought is important guidance regarding the two other aspects we mentioned in the beginning. On the one hand, the front determination, and on the other hand, the relation to proceedings in other jurisdictions. Let's start with the front determination. Here, the court made some very basic clarifications here, saying that front is a range. So this is the starting point of any front determination exercise. And the court also said that a fundamental principle is that the license income should be so high that companies and inventors have incentives to further develop existing technologies. So the court said that in principle, high license payments are basically welcome. There is, however, a ceiling, but the court said the ceilings would be reached if the license payments lead to the exclusion of parts of the global population from the use of technologies. So again, here rather tendency of the court to see that or to accept that the licensing income is important and is also very important when it comes to funding further investments and further inventions. Then, having said that, the court looked what is the best way to do the front determination. So what are the best tools that we can use? And here, globally, we have a discussion basically between two different approaches. The one is based on comparable license agreements, so agreements that have already been signed in the market. And the other one is the so-called top-down approach, where you try in very simple terms to look what would be the value of the total value of the technology for all the patents that are relevant for a standard, and then try to find out which is the share of the specific patent owner, and then make the apportionment of the part of the licenses, the licensing fees for the specific patent owner. The Munich District Court had a clear preference for the comparable licenses approach. It said this is the primary method for value determination because market mechanisms are best suited to reflect the value of licenses. On the other hand, the top-down approach was seen as problematic because basically it's difficult to determine or to find out which is the value of the entire technology. This does not mean, of course, and this is something that the court also stressed here, that top-down is totally useless. it can be used as a sanity check, more or less, to validate the amounts that have been extracted from the comparable license analysis. So since, of course, the court said that comparables are the main tool to use for the front determination, it went a little more into the detail in that respect. It said, well, if you look at the comparables, they have at least two roles. One, the obvious, to determine the front range, but another one is to illustrate the self-commitment of the patent owner. That's how the court described this here, if several agreements exist, which means, in other words, the, let's say, commitment of the patent owner towards the market of what is the amount it charges for its licenses. Now, the court clarified here, however, that this does not mean that one level of licensing or one specific set of terms that have been granted once will remain unchanged forever. The court said that at least a 15% leeway is always available for adaptations and adjustments. Having said that, it made also some guiding principles of how to use comparable agreements. One obvious rule is that you should basically not consider outliers at both ends, and by outliers the court meant particularly high and particularly low licenses. Then when it comes to licenses which have lump sum payment included, which involves also future uses, the court said if you want to see whether this license is comparable or not, you should focus on the assumptions that the parties made at the time of signing the agreement, because you could have very different developments going further. But if you want to see whether the terms that have been agreed are comparable to a specific situation, you should look at the assumptions that the parties had at the moment they signed the agreement. The court further had raised here some concerns, or basically said there should be some caution when the license includes past releases. They should be critically scrutinized, and the court also took the view that, as a rule, release payments for uses prior to the infringement notice shall be disregarded, or shall be subject to a substantial discount. When it comes to the range of the different license agreements of the patent owner that can be considered, the court said you can basically accept a factor of 3 between the lowest and the highest license, and in certain circumstances you can even go above that, especially if you have agreements with users with particularly high volumes. The question that is raised here, of course, is this maybe discriminating smaller licensees, but the court found that this is not the case here, by saying if smaller licensees seek licenses proactively, then they have a very high likelihood that they get good conditions, because in the view of the court, enforcement in this context is not in a good relation to the income that you can have in absolute terms from this type of licenses. Then very briefly on which licenses are to be preferred. Basically two categories here: licenses in which the patent owner is involved, and licenses in which the patent owner is not involved. So the court had clear preference here for licenses in which the patent owner is involved, so licenses that the patent owner has granted basically to other implementers. These licenses should be the primary source for establishing portfolio value, and particularly licenses that concern the same portfolio not so far in the past. So relatively recent licenses have even a higher value than others. Quality criteria for the licenses of the patent owner: the size and the product range of the licensee, scope, and the duration of the license. Particularly important or having a substantial role are agreements of the patent owner with the specific implementer who is in the proceedings. So previous agreements between the parties have a substantial role in the eyes of the court. The court clarified here, however, that if the parties had already an agreement, as we had seen here between ZTE and Samsung, this does not entail a claim to have a new agreement based on the same conditions, on identical conditions. The court said adjustments are of course, can be done and are logical to an extent, especially an inflation adjustment is the minimum that parties should accept. But apart from that, the court said the whole arguments of the parties in favor or against potential adjustments is something which is important because the court can take this up and look it up in the context of deciding whether the parties have been willing or which party has been willing to get into a new license or not. But the court also made clear, however, is that licenses in which the patent owner is not involved, they have no direct importance for the determination of the front range. Does this mean they are totally irrelevant? Again, the court said here, no, this is not the case. These licenses can be used for a plausibility check. But again, they are not the primary source. So the primary source, licenses of the patent owner, and even more important, licenses of the patent owner with the specific defendant or the specific implementer in the specific case. Finally, the court said here the calculation method. There are several ways to calculate the front royalties, but the court had again a very clear preference for per unit calculation because it found that it's best suited for establishing clear rules for both patent owners and users. This means, of course, that the number of the units sold is a decisive criterion. And here the court made a comment which I think is interesting. If you are having difficulties to have a forecast for future sales, or the parties cannot agree on a specific number, then the court had some concerns whether a lump sum agreement would be the right thing to do. But even if you would take this path and make a lump sum agreement, the court said usually you should then agree adjustment mechanisms. This means again that the court did not say that other methodologies apart from per unit calculation are excluded. It preferred this calculation and also said that in case that the parties choose another way to calculate the royalties, the court will regularly make a plausibility check based on a per unit value. So again, this indicates that the court seems to have a very strong preference for this type of calculation when it comes to the front determination. Finally, the court gave also some guidance on how to deal with foreign proceedings. We said already, particularly with also with this type of interim license decisions that come from the UK recently. Very generally, the court said that, and it disagreed with the High Court in that regard, that there is a risk of diverging decisions that needs to be mitigated by allowing only one court to decide about everything. The court said this risk is not really given when all courts respect their national borders. Having said that, it made clear that decisions of foreign courts are not binding for German proceedings. And it said that it's a non-negotiable condition that you should not allow a claimant that has raised an action abroad to use these proceedings abroad to cause effects on the defendant that expand outside of this jurisdiction. So the court said, of course, parties are free to decide if they want to expand the effects of proceedings to other jurisdictions as well. But if there are circumstances that justify that, the court will review this decision of the parties, especially if the consent of one of the parties is granted in the wake of the concrete procedural situation, which means rather under a specific kind of pressure. The court also highlighted here that the Munich courts have so far offered measures against this type of these foreign decisions that could disrupt German proceedings, especially the anti-suit injunction case law of the Munich courts was mentioned in this regard, and the court explained that it is in the interest of the patent owners to keep the few venues that are available for enforcing patents operational, so that especially when it comes to Germany, foreign decisions that aim at blocking injunctions will need to be countered by the German courts, especially since in the German system, the injunctions is the remedy that's prioritized, especially over damages, which in the German context are rather complex. Regarding the interim license declarations in the UK, the court did not see that they are now immediately a threat to the decision authority of the German courts. It did not equate them as they are now to an anti-suit injunction, basically because the UK High Court had made an express clarification in its judgment that the decision has no effect on the German proceedings. Certain claims, however, raised by the parties could change that. So the court left here the door open to eventually look at countermeasures if this situation changes. And having said that, finally the court turned to the interim licenses. It's very specific new remedy that comes from the UK and can have implications for German proceedings. Generally, the court said it's the parties' choice to conclude an interim license if they like to, so they are free to do that. But the court said there is no legal claim that the patent owner consents to the conclusion of an interim license. And from an objective viewpoint, the court had also doubts whether truly willing parties would need to refer to take recourse to an interim license. Why? Because the court said usually parties that are truly willing to get a license done, they have sufficient time to do so. Even the 9 to 10 months in which German patent proceedings are pending should be sufficient in the eyes of the court for truly willing parties to agree and sign a license. And especially if only the license amount is open, the court asked itself what would be the additional insights that you could have by putting an interim license in place and basically delaying further the conclusion of the agreement. What the court also stressed there is that in a context where you have the parties requiring different courts to make front determinations, of course, you cannot argue that there is an interim license in place or that the parties would like to have that. So this is something that was the case here, for example. We saw there were rate setting requests in the UK, but also in China. So in this case, the court said if you want to have a global determination, this is only possible when both parties agree. So if each party chooses a different venue to do that, then per se you cannot have an interim license in place. And finally, looking at the specific decision of the UK High Court in the case between ZTE and Samsung, and especially the finding in this decision that a willing licensor would submit itself to the UK proceedings, the court said that this decision is remarkable. And why? Because it didn't see any factual grounds why the English court, the High Court, would be the proper court to determine rates. As in the present case, no party is seated in the UK. and the UK is neither an important market nor a manufacturer base for either ZTE or Samsung. So the court did not see really a justification why you would say that a willing licensor would submit itself to a FRAND determination by an English court. On the contrary, it saw that this ruling can impose a factual pressure on the affected party, which, as we said before, basically is something that the court in Munich sees with great concern.